Thanks everyone who's logging on right now. We're just going to give everyone one more minute to sign on and then we'll get started. All right, it looks like we've got a number of people, so I'm just going to go. My name is Cece Mortar. I'm the programs manager for the Steamboat Springs Chamber. I want to start by giving a shout out to our presenting sponsor for this series, Mountain Valley Bank, and supporting sponsors, the Employers Council, Northwest Data Services, and the Colorado Housing and Finance Authority. Without them, these events truly wouldn't be possible. And I would also like to welcome our employment law expert for this series, Tina Harkness. Many of you have seen her before, but for those of you who haven't, Tina is an employment law attorney and general counsel for the Employers Council, Employers Association that's been supporting Colorado for over 80 years with all of their HR and legal needs. We have a lot to cover today. So Tina, I just want to thank you for joining us, and I'll let you take the reins from here.
Thanks, Cece, and good morning, everybody. It's nice to be back. You might recall, or some of you might have attended an employment law update I did in May. So I'm going to be following up on some items from that session as far as some practical to-dos from the Colorado legislative session. I am also going to be going through a bit of a federal update because we have had some things drop that were anticipated, but hadn't happened yet. So I couldn't quite give you the information until we have it, but now we do. So we're going to go ahead and share some slides. And I know you have. Somebody always asks the question of, can I get the slides? Yes, you absolutely can get a copy of the slides. I haven't sent them to Cece yet, but I will right after this session. So she'll share that with those folks who can't attend and watch the recorded version, and she'll share the slides with those people that are here today. As you have questions, you can go ahead and put those in chat. I'll try to take a break just midway through to catch up on any questions. If I see something come through in chat and I can address it right away, I will go ahead and do that. But please go ahead and put those in. All right, we're going to bring up the slides. So let's do this. All right. Are you guys seeing slides? Pretty well there? Yep. Okay. Let me do one more thing. All right. So for our time together today, like I said, we're going to do some federal and Colorado changes and some trends that we're seeing in the employment law world. Those are always a little bit harder to tackle, but generally towards the end of the year and towards the end of the federal and Colorado legislative session, some things kind of percolate out. Oh, here's the necessary stuff. Of course, none of this is specific advice for your organization, but you can get that specific advice for your organization if you have a particular situation or you want to know specifically how some of these changes apply to your company. Please don't hesitate to reach out to your legal advisor or to Employers Council for assistance. For federal, just want to make sure everybody's seen that there's a new I-9 form. And of course, we get a new one every so often. The last change was kind of a bigger change. This one is another bigger change to the I-9 form. Last time they expanded the form and now they're contracting it again. So we of course do not need to redo any old I-9s for current employees when we get a new I-9 form. I just want to be very clear about that. This is for new hires. You can already be using this new I-9 form. I think it came out in August. But you must absolutely be switched over to the new form by October 31st of this year. So as I said, they're contracting the form. It's going back to one page. And it's going to have two sections, really the section 1 and section 2, right? Section 1 that the new hire fills out on or before their first day of employment, identifying themselves and their status for authorization to work. And then section 2 that the employer fills out when you see documents that verify that person's identity and authorization to work. What they're taking off of the form to get it back to one page is the section 3, which is for re-verification. When you have somebody who has a work authorization document that expires at a certain point, they're also taking off of the form the agent. If you use an agent, so you can't actually do the I-9 process yourself. Maybe it's a remote worker, you hire somebody to do that. There's a section of the old form or the current form that you could have that person fill out. Now, that's going to be a standalone supplement. They're also going a little more high tech with this form. It will be fillable on tablets and mobile devices, which will bring them sort of up to date, right? And hopefully make things easier for employers that way. And they've added to the list of acceptable documents some of the receipts that are allowed. So in some situations where someone is waiting on a document or a document has been lost, they will get the employee will get a receipt, and they can be used in some circumstances and they can't be used in some circumstances. So for the initial hire piece, the list of acceptable documents will include those receipts. There is information and access to the form. They have good instructions. They have kind of an example of how to fill out different sections of the form. So I gave you that link. And then we're going to talk about next another big change, which is good for some of us. There is going to be a checkbox on the I-9 form that allows that confirms if you are an E-Verify employer that's using an alternative procedure from the regular procedure. So the regular procedure is that the employee, again, the new hire, on or before their first day completes section 1, and on or before their 4th day of employment, that you actually meet with that person. They bring in physically the documents that they're going to provide to you, documents that someone from your company or an agent that you have designated physically inspects those documents. That's the normal process. So they're handling the original documents. The alternative procedure, though, will be something like what was permitted for COVID precautions, where we can do a remote inspection of documents. So while we were taking COVID precautions, when we didn't have people working in offices, if that applied to your organization, there was this ability to remotely inspect documents. Now, if those employers had to hurry up and physically inspect those documents, many of those employers had to do that by August 30th, since most employers were not still taking those COVID precautions. But we are getting a new process for E-Verify employers. So what's E-Verify? E-Verify has been around for some time. That is a system of where employers who are part of that program enter in their new hires information, and it is checked against certain federal databases to determine if there's a match. And if there is a match, of course, that's good. If there's not a match and there's a non-confirmation, that's not so good. So employers who have had federal contracts and subcontracts have been required. In some cases, certain states have required employers to use E-Verify, or if you were a contractor with a state, you may have been required. It's not required of every business to use E-Verify. it is optional for those non-required businesses to participate in the E-Verify program by signing up with a memorandum of understanding with the federal government that you're going to follow all of their rules. And in the past, the advice has been, why subject yourself to another set of rules? Because there are a lot of them. And even if you're not, even if you're doing the program voluntarily, if you mess things up, you can still have consequences. So that advice might change with this new latitude for E-Verify employers to use an alternative procedure. And that is this, that's virtual verification of I-9 documents. So again, in lieu of that physical inspection. To do this, you can only do this for new hires, even if you already are an E-Verify employer, for new hires after August 1st of this year. You have to be enrolled in E-Verify and in good standing before you begin to use this alternative procedure. And there are a number of steps to this process. So you're going to still give the new hires a list of acceptable documents before, right? You do this virtual verification. You're going to get copies of those documents front and back if they have information on both sides. And then you would conduct a live video interaction, similar to what we're doing today, where the new hire is going to show you the same documents that they sent you copies of, again, front and back. And of course, you'll use the new I-9 form for this because that has that checkbox in section 2 where you indicate that you use that alternative procedure. And then, of course, you're going to follow through because you're an E-Verify employer by submitting your E-Verify case. And you do need to retain, as part of this process, copies of those documents that were submitted to you. So if you are an E-Verify employer, you can choose to offer that alternative procedure for all employees at a site, or you could do that just for remote hires only and continue to follow the physical inspection procedures for employees who work on site or partially or fully. So that is really up to you, but this is another modernization of the I-9 process, and hopefully it is something for those of you that are E-Verify employers that save you some time and some effort. Moving on from the I-9s, I want to make you aware of a couple of Supreme Court decisions. The Supreme Court term runs from October to generally June. So it always bridges, right, a 2-year span. So the 2022-2023 session ended at the end of June this year. And that's usually when the decisions come out, like the major ones come out right at the end of June. And here's a couple of them. The Groff versus DeJoy case affects all employers in the United States who might receive requests for religious accommodation from their employees. So for over 50 years, the standard has been from some previous Supreme Court precedent that employers did not have to accommodate an employee's religious belief if it was more than a de minimis cost to the organization to do that, or if it would interfere with the efficiencies of the operation or violate a collective bargaining agreement with union employees or some kind of seniority system. So we didn't have to extend ourselves maybe terribly far if there were some business impacts of a request for religious accommodation. That is no longer the rule with this decision from the U.S. Supreme Court. So that ends that de minimis standard I mentioned. And it's redefining undue hardship in the religious accommodation context to be substantial increased costs. Well, these are just words, right? How substantial is substantial is going to be the question that now has to be answered under this new standard. this Groff versus DeJoy case involved a former postal worker who sued the U.S. Postal Service for failing to accommodate his Sabbath day off. He observed Sunday as a Sabbath and did not work on that day. Now, the U.S. Postal Service doesn't deliver mail on Sundays, but it did have a contract to deliver packages for Amazon on Sundays. And they looked for people to work voluntarily on Sunday shifts to cover for Groff, but they couldn't cover them all. And eventually they started imposing progressive discipline for his absences, and he resigned his employment. So they made an argument that exempting him entirely from those Sunday deliveries was an undue hardship. And they were successful at the lower court with that argument, and at the Third Circuit Court of Appeals. So at the next level too. But when this got to the Supreme Court in a unanimous decision, so that's interesting considering the split of conservative and more liberal justices on the court these days, but it was a rare unanimous decision from them. And the first time again in 4 decades, the Supreme Court has addressed accommodation of religious beliefs in the workplace. They basically said, we need to increase this threshold. So we don't have the specifics of what substantial means, but we know from the Groff case that it's more than inconvenience, and it's more than a negative impact on coworkers, or even more than requiring coworkers to work overtime, because that was not substantial enough in this DeGroff case. So courts were going to have to start examining the impact of the accommodation on the employer's business. So that's going to take into your account your size, your operating costs, the nature of your business. Larger employers with more resources certainly may have a harder time denying religious accommodations requested by their employees under this new standard. I would expect more religious accommodation lawsuits as a result of this. Sabbath accommodation applies to a number of faiths. So what I would say for employers is just be sure if you're getting a request for the employee that you're not dismissing it out of hand, that you are exploring options, even if you can't do fully what the employee is looking for, and talk again to your legal counsel about those. The second decision isn't actually an employment case, but it's one I'm sure you heard about, or you may have heard about. And that is a case that challenged affirmative action in college admissions. And this was actually 2 cases that were consolidated, one against Harvard University, one against the University of North Carolina, where they had race as a plus factor among many other factors in their admissions decisions. And this has been challenged in the past, and it's withstood scrutiny of the Supreme Court in the past, but it did not this time. So in a 6-3 decision, the Supreme Court said that using race as a plus factor in college admissions violates the Equal Protection Clause and the 14th Amendment of our Constitution. So the majority determined that while pluralism and diversity and other values in education are commendable goals, they're not sufficiently coherent. So they're too fuzzy, is my phrase for that, to survive the strict scrutiny that the Constitution requires of any kind of racial preference. So that is the decision. I point this out because we also know that there is affirmative action in employment for federal contractors and subcontractors. And again, while this case does not directly affect affirmative action in employment, we've certainly seen a response since this decision at the end of June of maybe corporations that had highly publicized DEI programs, being a little quieter about those things, or even backing away from some of those initiatives because of some uncertainty of whether this will spread to the employment context and overturn affirmative action there. It's not gone yet. So if you are an affirmative action employer, please continue to do your plan and meet your obligations. But I did want to make you aware of this decision, since it could be a harbinger of some future changes in the employment world. A couple of regulatory things to make you aware of. The EEOC, that's the Equal Employment Opportunity Commission, has issued what they call a technical assistance document on visual disabilities at work. So sometimes they take and provide specific guidance on certain disabilities, and that's the case here. And it's not binding rule or regulation, but it is guidance for employers that are working on accommodating employees with visual impairments. So it has a decent amount of information, and not always, but we do see courts relying upon federal agency guidance from time to time in making their determinations. And even more than that, just us in our day-to-day management of employees who have disabilities that affect their jobs, this can be a resource to you. So it does cover when employers may ask applicants or employees about visual impairments and what they should do if there's a voluntary disclosure. It gives some examples of reasonable accommodations that applicants and employees may need. For those of you who have them, it talks about how you would handle your safety concerns if someone is visually disabled and working in your workplace, and has a piece about how you can prevent an employee from experiencing harassment because of their visual disabilities. We're going to come up on the other guidance in a second, but I also wanted to point out a shift in the wind, so a trend. So the NLRB is the National Labor Relations Board. They are the governing body for the National Labor Relations Act, which applies to all private employers in the United States. And this is the law that allows employees to form unions and bargain collectively with their employer. Even if you don't have a union, portions of the NLRA will still apply to you as a private employer. There is a general duty, or excuse me, not general duty clause, but there is a protected and concerted activity section of the National Labor Relations Act called Section 7. You might hear that, that allows employees, even if they don't have a union in place, to be protected from their employer retaliating against them because they banded together to get better wages, hours, or working conditions, or to communicate to others about their wages, hours, and working conditions. So the NLRB has now, they have 5 members, and and different parties have control, right, depending on when those members are appointed. And when the shift in power is when you get enough members on one side of that fence to shift the power, then you start getting changes in their focus and their enforcement. So the National Labor Relations Act, it doesn't shift automatically with a new administration. Now that National Labor Relations Board is predominantly Democrat, and they are undoing decisions that the predominantly Republican board made before. So this has happened time untold and will continue to happen into the future as we have different parties having different views of these issues. So you might remember some years ago when and during the Obama administration, when the National Labor Relations Board went after a bunch of handbook policies. Well, that's the shift here, and that's what's happening again. So the Stericycle case really reverses a previous decision made by the Trump appointed NLRB members on this issue of Section 7 rights and how handbook policies can affect those rights. So if we write very restrictive, overly broad handbook policies that the National Labor Relations Board and their general counsel think will chill our workers' exercise of their Section 7 rights, then our handbook policies can be unfair labor practices under the National Labor Relations Act. So the Stericycle decision reversed the previous decision. I don't remember the name of that one, but basically said that overbroad work rules can interfere with Section 7 rights. The general counsel of the National Labor Relations Board followed up on that decision and basically said that employers have to show in the second bullet that if they have a rule, that it is narrowly tailored for a specific, legitimate, and substantial business interest. So the policies that are most at risk, if you have them, are some general civility policies. Not every employer has those, but some employers have them. The no camera, no video, no recording kinds of policies. That was one of the ones that was fought out previously in a Whole Foods case that you might remember hearing about. Social media restrictions, confidentiality of workplace investigations, general confidentiality and non-disclosure provisions. A lot of employers have those. And if you have limits on media contact. So if you have those policies, you might want to have your legal counsel take a look at those just to see if there needs to be some refinement of that language to specify what legitimate purpose you're working towards here. And also to maybe add some carve out language. It really is just something that says this is not intended to interfere with workers' rights under the National Labor Relations Act. So something that's just like an add-on at the end might be super simple if you have those policies. This is the other regulation I wanted to point out. Pregnant Workers Fairness Act was one of the piece of legislation that we've talked about previously. The Equal Employment Opportunity Commission again enforces this, and they issued proposed rules on the Pregnant Workers Fairness Act. So this goes beyond guidance. The rules are proposed, and now we're in a point where employers can comment on those rules, can review them and comment. You have an opportunity to comment through October 10th if you wish to do so. And there's a website that you can do that at. And then they expect to issue final regulations at about the end of the year. So the Pregnant Workers Fairness Act covers employers with 15 or more employees. That's all employers, public and private, and requires accommodations for pregnancy, childbirth, and related conditions. You can, under the guidance, request medical documentation where the need for accommodation isn't obvious, which it isn't in many cases when we have a pregnant employee. It identifies a number of limited or simple modifications that will be found to be reasonable accommodations in most cases, and that likely won't rise to the level of undue hardship. We're using this phrase again, but in another context in this situation. So modifications in the proposed rule are things like, allowing an employee to have water or a drink as needed in their work area. Some employers don't permit that. Allowing additional restroom breaks, allowing employees whose work requires standing to sit and whose work requires sitting to stand as needed. So those are some of the things that they specifically called out as things. Employers aren't prohibited from requiring an employee to take leave, either paid or unpaid, if another effective accommodation exists and doesn't rise to the level of undue hardship. And you will have a notice that you need to post describing the Pregnant Workers Fairness Act. Now, Colorado employers, you're probably saying, Tina, that you're singing the same tune I've heard before. Don't we have a Colorado law on this? And yes, we do. And we've had that in place. And that is actually in place for Colorado employers, regardless of size. There is a carve out for certain religious organizations that aren't supported by public money, but you're probably not dealing with anything more than what you have already been dealing with. But if you do want to take a look at the proposed rules and provide some feedback on them, you can. The big controversy with this is that they included abortion and abortion services in the pregnancy, childbirth, and related conditions, and some individuals are opposed to having that in there, so they're getting feedback on that, as well as some other pieces. I think this is my last slide on the federal, but I wanted to point out we had our first AI discrimination lawsuit that the EEOC has settled, and that was settled just in August. And the allegation was that this firm was using AI-aided recruitment software to review resumes and applications from applicants for employment, and that software was programmed to reject applicants based on age. So interestingly enough, it was allegedly programmed to reject female applicants over 55 years and male applicants over 60 years of age. So I don't know how they determined that, but that was something in the article about this. And the settlement is $365,000 that will be split among 200 plus applicants that were in the age protected category, which is 40 and older, and were rejected for these English language tutoring jobs. So the applicants, interestingly enough, figured out what was going on by basically resubmitting. They submitted their application and were rejected, and then they resubmitted identical applications, changing only their birth date, and then were asked for interviews. So that's how they figured out that something was fishy about this situation. So that was kind of an interesting case, and we'll see more of this as employers use AI. There's lots of great uses of AI in many workplaces, and they could also be used to discriminate. Oh, last one. We are going to get a change to the federal salary basis level. That was proposed and issued just last week, right? Just a couple of weeks ago on September 8th. So the federal level right now for an employee to be exempt from overtime is $35,568 per year, or $684 per week. So the change would boost that up to quite a bit, right? To over 1,000 a week and 55,000 a year. And the highly compensated exemption will go up from about 108,000 to about 144,000. So that's a related exemption that requires some duties to be performed. The proposed rules also have automatic updates for every 3 years. And there's the opportunity to comment through November 7th. This is going to get challenged. It's already happening. And you might remember the 2004 change when they were going to boost up the salary basis test to a lower amount, from 24,000 to 48, I think it was about 48,000. That was blocked 1 week prior to implementation. So some of you had already made your changes. Some of you were poised to make your changes. So that's going to be attempted again. And basically the challenge was that that boosting that salary level so high, so fast in one big jump, would basically make the rest of the the test for exempt status redundant, moot. You wouldn't even have to look at that because it was going to just about make everybody non-exempt in that case. And in that case, at that time, they were anticipating about 10 million people having to be reclassified from exempt to non-exempt, or having to have their salaries raised to continue to be exempt. Now, although this is a higher standard, it's not as big of a jump from 36 to 50. Well, yeah, math is not my specialty, so nobody quote me on that, but it's they're only anticipating about 3 million workers. It's still a lot that will be affected by this. So the good thing is they're not changing anything else. They're not changing any part of the duties test or the salary basis test. So we're used to those. I mean, they're not easy to deal with, but we know what they are. And also a reminder that states may have their own salary threshold. We know for private employers here in Colorado, we're already required, or we will already be required to pay exempt employees almost the same money, right? Very, very close to the same money beginning January 1 of 2024. And then we will have annual increases for, again, private employers only in Colorado after 2024. So every year, the January 1 will have an increase to that. So just a reminder, that is happening. So for public employers, you have subject to Colorado's requirement. So jump in from 35, if you have somebody making that now, up to 55 may be a big stretch. Or you might have people in between, right? But that aren't at 55. And you're going to have to, get out your pencil and pad and do some figuring on what works best for your organization, for those individuals who will drop below that minimum salary level, because they will not be able to continue to be exempt. So are you going to budget to increase salary? Are you able to budget to increase salary that much and keep them exempt? Or are you going to be switching them to non-exempt, which is a challenge in its own, because employees sometimes don't want to be changed to non-exempt. They're considering it a status that might be lost by that change, even though they would get paid then for every hour that they work and be paid a premium for any hours that they work over the overtime threshold. The other thing that comes with that, though, is they will have to start tracking their time, and that can be a difficult adjustment for somebody who's been an exempt employee that hasn't had to think about what is work time and hasn't had to record their work time before. All right, Cece, any questions we got on what we're talking about in the federal?
You do. You have a couple questions in Q&A and a couple questions and comments in the chat. So I think the ones in the chat came in first. So for the Pregnancy Fairness Act, does related conditions include infertility and treatments?
I think so. Take a look at the proposed rules, but I do think it does.
Okay. And I think you covered this for private employers. Colorado already has this minimum exempt of $1,057 a week.
Yep.
What are the benefits to employer or employee exempt?
What are the benefits? Well, the difference is if there's an exempt employee, then they do not receive overtime pay. So they have a regular salary, and that regular salary, again, for most exempt employees, there's some exceptions always, but they have a regular salary. It has to exceed whatever the minimum level is, which is what we're talking about them changing. They don't have to record their time. Those are the differences. So these are statuses that employers have to decide for every worker. So it's, do they fit in one of the boxes that makes them exempt, or do they not? So so when you talk about benefits, of being exempt, I think I would think about it more like differences. I mean, an employer could lawfully just have all their employees be non-exempt if they wanted to. And then they wouldn't have to go through the examination of the position to determine if they could make those positions exempt. But I think typically employers appreciate having where people fit some exempt employees where they don't have that overtime requirement and that time tracking requirement.
What if a currently exempt employee, sales, gets a lot of commission? This thoroughly compensates for overtime associated with commission.
So sales is tricky. Most salespeople are non-exempt because they are inside salespeople. They're selling by phone, they're selling by email, they're selling by Zoom now. You know, there is an exemption for outside sales people who are truly on the road most of the time, making sales, following up on sales. But that is a very high threshold to meet. So highly paid salespeople may meet the highly compensated employee exemption, or they may be non-exempt and meet an exemption from overtime. That's not the same. It's overtime only that they're exempt from. So sales is more complicated, but we have had a case where a very highly paid salesperson, right, did not meet or was found to be non-exempt, and the employer owed a substantial amount of overtime, right? Because those salespeople generally do work more than 40 hours a week. They're working all the time. So you do want to look at all your options and figure out which carve out you might fit into. But having them just be highly paid and, you know, way above the salary threshold is not going to be enough if they don't meet the rest of the tests, unfortunately. And that's a situation a lot of organizations have.
Along with this question, can you define highly paid?
There's a test. The highly compensated exemption, we saw the numbers. Right now it's 107,000 and some change. It's going to go up to 148 for the year. At least a portion of that will have to come from salary. If they're going under the highly compensated exemption. So we don't have time to go through all that today, but those numbers are in the slides that you'll receive, and then the rest of the test I can send to you.
Okay, hold on.
And Colorado also has a highly compensated threshold. I didn't highlight that in my slide, I just realized, but they have a highly compensated employee threshold. That's about where the federal one will be with this change.
Okay. For the other comments in the chat, yes, we'll send the law in the follow-up email and the test as well. This goes, 2 more questions that go back to the age issue with the AI. Why are they having to enter their birth date and all, and how do you keep age out of the question?
Right. Well, you just don't have that, right? You don't have them enter it. So that was a question in my mind too. You know, how are they figuring that out? Because many employers took birth date off, and instead we substituted a question that says, are you at least 18 years of age, right? Because then we have to know that for child labor. So this employer was a little behind the times anyway. Because most people wouldn't put that on their resume, and I would not advise them to ask on the application either.
All right, thanks, Tina. And if you guys have other questions, you can put them in the Q&A or the chat as we go, and we'll answer the rest at the end of the session.
Yeah, this will be a little bit quicker, I think, the Colorado portion. I'm just following up on, things that are in place and things we talked about in May here. and we should still get done on time. Oops. So I wanted to follow up on the family program, and just make sure that for those employers who did not have the option to opt out, who are looking at that private plan, the same or better private plan alternative to participation in family, there have been some new things. So of course, Colorado didn't get the private plan rules out, and they didn't get the private plans approved in time for employers to not have to withhold their premiums starting January 1 of 2023. So we've been paying those premiums, but if we are getting approval of our private plan, you may be able to get your premiums back if you get your stuff in by the end of October here. So you can get those refunded. If not, you can still submit your private plan, but you just won't get a refund. So they have added to their website, and this is actually a pretty useful website for figuring out family. They have added, and they're continuing to add, the private plans that have been approved if you're going to go fully insured with a carrier. So they're listed, and this is the link to get that if you're exploring that. And then they also have, if you are doing the self-insured route, they also have some really good resources for that. If you're going to do your own private plan, you have to have a surety bond in place for 1 year of premiums. You have to have a plan for your program, but they have a sample plan on their website that is really just a plug and play. You can fill in the blanks on. So I wanted to point you to this page if you're in that process. And just to update you that they will start accepting applications from employees who want to receive family benefits in Q4. So we're almost there. And then leave benefits, of course, will not begin until Q1 of 2024. And I also wanted to, because I've gotten a number of questions about, well, how much, would somebody get? I also want to make sure you know that there is a premium and benefits calculator on that family site as well. If you're just doing family, or you're a local government, public sector, and you've opted completely out, then this is not information that you need. So we did talk about in May what was happening in the legislative session. It had ended, but not everything that passed through the houses was signed by the governor, and we didn't have some of the rules and some of the guidance on what we need to do there. So I wanted to give you some to-dos after the 2020 session, starting with the Colorado Healthy Families and Workplaces Act. You had this in your May slideshow, but it was signed. We did that session, end of May, and it was signed beginning of June. So what you need to do with this is add to your paid sick leave policy. This is, again, all employers. You need to add to your paid sick leave policy these reasons. So they're basically adding in not just closure due to a pandemic, right? They're adding the ability for people to use time to care for their family members, their kids, when there's a weather emergency or a loss of power, water, or heat emergency, or something else unexpected that is major. And then they also added funeral, memorial leave, and to take care of the financial and legal matters that have to get done after the death of a family member. So I would take a look at, if you have it, your bereavement or funeral leave policies in light of employees now being able to use Healthy Families and Workplaces Act paid sick leave for funerals and memorials and those financial legal matters. You might not do anything with it. You might just keep it as an extra additional benefit, but then you would want to figure out, does that come first? Does Healthy Families come first? You might want to figure out the order there. Or, you may revise or change your bereavement or funeral leave policy in light of this. The Colorado Department of Labor and Employment has updated their info document. This is a guidance document, so it's not a rule or a regulation. It's guidance for you. 6B is the number, and I've given you the link here. They were defining, how bad the emergency had to be, if it's weather, or power loss. So they had an example that I thought might be helpful on what is an evacuation. And that really requires a home not just to be less comfortable or inconvenient, but essentially uninhabitable. Though it doesn't have to be completely unsafe. So they gave this example of these two employees, Yesenia and Norbert. They temporarily leave their homes after a tornado. Yesenia's house, the roof is ripped off. Norbert's house, there's a window broken and the neighbor's dog is going a little crazy. So Yesenia gets healthy families leave because she shouldn't have a roof, and that makes her house uninhabitable. Norbert doesn't get healthy families and workplaces act to leave because he just has a broken window and a loud neighbor dog. So these are going to be very factual, sometimes difficult situations for us to handle. Again, we're Employers Council, we're here to support you. They're trying to give you some guidance, so I wanted to point it out to you. For the POWER Act, so this was the change to the standard for what is unlawful harassment in the workplace under the Colorado Anti-Discrimination Act. That was also signed at the beginning of June. So if your anti-harassment policy likely needs some updates. If you have severe and pervasive language in there, you probably need to take that out. You also want to be proactive about making sure that you have the defense that's available under the POWER Act. Again, you should have these things in place already, because if you're over 15 employees, the federal law has required them for some time, but just take another look, making sure you've got a good complaint procedure and investigation response, and that you're taking prompt remedial action. So that's what's designed to stop that problematic behavior from happening again when it's warranted. And then communicating the details of your anti-harassment program to your supervisors for sure. And I think also it's a good idea to make sure that your employees are fully aware of what is going on there, what your processes are. You also have a record keeping requirement under the POWER Act. So I've listed the records that you have to retain for at least 5 years. So make sure you're keeping those, because you did not have that specific of a record keeping requirement prior. Now, most employers do keep their current employee files for the life of the employee and for probably 3, 5, or 7 years after. But just make sure you're taking a look. And some of these things may be combined records that you haven't created before, like requests for accommodation. Those were probably in individual employee medical files, whereas unless you were an affirmative action employer and then you keep a log of your request for accommodations, well, now you might want to convert to not only having it in the employee file, but also in a log. So you can access it. Same with complaints of discrimination or unfair employment practices. Again, you probably had your applications and your hiring records and termination records and pay records already in those files. Just make sure you're keeping them for 5 years. If you are under 25 employees, you haven't had the requirement until now to prohibit discrimination based on marital status. That was 25 and plus employers. So now you do need to add that to your anti-discrimination policy. And I just wanted to note that employers with 26 and more employees can still follow Colorado's rules about when you can discharge or not hire or not promote spouses or civil union partners where there are supervisory, auditing, or other confidential relationships exist. If you're under 15 employees, you're, excuse me, you have not been subject to the federal ADA, you've been subject to Colorado Anti-Discrimination Act's requirements that are very similar for disability accommodation and prohibiting discrimination. You're going to need to remove any language that says that a disability has to have a substantial impact on the job from your disability accommodation policy. And then for those of you who have non-disclosure agreements, they need to be looked at. They need to be looked at not just for Power Act changes, for some other changes as well, because they're getting harder and harder to have. These things are not right away. The Equal Pay for Equal Work Act is been around, has been around for a while, since the beginning of 2021, and the job posting piece has been the hardest piece. The pay equity cases are starting to come, but mostly we've been trying to deal with the job posting piece. Now we have some additional requirements. So it's not effective. These things are not effective till January 1 of 2024. So please don't worry about if you don't have them today, but you're going to be adding an application window to your posting. So how long that window is going to remain open, and you're going to be letting coworkers of a selected candidate know certain things about the candidate within 30 days of their hire. So those are listed here. So get ready for that. You don't have that yet. The Colorado Department of Labor and Employment has also updated Info 9, and they've done some good things here. They have actually taken out some of those non-competitive situations from the job posting requirement, which, you know, has been some of the hardest stuff to handle. So career progression promotions do not need to be disclosed for each individual employee. So career progression is regular or automatic promotions that are based on time in the role or other objective metrics that an employee can satisfy without competition. So some of you have those. And prior to now, the language would have required you to post those, which seemed silly. So now you'll have some support for that. Also, career development promotions have been carved out from posting. So career development reflects work that they've performed or contributions they've already made by one specific employee without competition. So you could have some of those situations where, again, only one person is going to get that job. It's part of their development plan. So we won't have to post those anymore, which is going to be really nice. The Job Application Fairness Act, again, this is requiring, which your colleague pointed out is already something you should be doing anyway, which is removing questions about age or requiring date of birth on or dates of attendance at educational institutions from initial employment applications. Now, some of you have to verify age for certain reasons. You can still do that. But this is, again, public-private employers, and it's not effective until July 1 of next year. So that's why it says prepare there in yellow. Oh, shoot, I'm over time. CC, the rest of these are no to-dos, but I just wanted to follow on and give you the actual days that those bills were signed. So those are more narrow. So how are we doing? Did everybody leave already?
We're good. We have a couple of questions. And while I ask these, if anyone else has some questions, you can put them in and we can go a little bit over. Tina, if you have time, that is.
Yeah, I do.
So the first question, for employers who are not paying the high premiums of group health insurance, what are some tax advantage options you recommend to help employees with premiums and uncovered costs of health coverage and expenses? And do you have a contact for more info on this so we can investigate?
You know, I'm giving a presentation on employee retention next week for this group, and we specifically carved out the health insurance and benefits portions because that's not my area of expertise. So I apologize, I don't know of those things. I hope that they exist. I believe that they may, and that there's somebody who's smarter than me about that stuff can talk to your group about that.
Okay, thanks, Tina. And I will look into this and respond to the group if I can find information on it. If an organization has unlimited PTO, is a separate sick leave policy needed?
So you can satisfy the Healthy Families and Workplace Act with a general PTO policy. You have to have certain language in your PTO policy that indicates you're doing that. And I would still add those new uses so that that's clear. The general PTO policies are great, and we were all moving towards them, right? And now, and we didn't have to track, and we didn't have to know why people were gone. Well, Healthy Families kind of came in and wrecked that a little bit, because you do have a tracking component. So you do need to know, you do need to be tracking when people are using your PTO for Healthy Families and Workplaces Act reasons. So that kind of blew some of that flexibility out of the water, but yes, you can use your PTO for that.
Okay. That looks like all the questions for now. So I just want to thank everybody for participating today. We're going to send the recording and the slides out this afternoon, along with the exempt, non-exempt information that was promised earlier. As Tina mentioned, she'll be joining us on September 19th for a session that focuses on creating policies that foster workplace retention. So I'll include that along with some other upcoming sessions in the follow-up email. I want to thank our sponsors again, Mountain Valley Bank, the Employers Council that Tina works with, Northwest Data Services, and the Colorado Housing and Finance Authority. Thank you, Tina, so much for your time. This is really helpful. I know a lot of people will probably dig into their employee handbooks after this, myself included. And yeah, have a great rest of your day, everybody. I'll be in touch soon. Bye.
Bye.